Good morning. Can you both hear me?
I can hear you.
Yes, Your Honor. Good morning.
Okay.
Good morning, Your Honor.
So we're here on the case of State Farm versus Bergman. These arguments are being live streamed so the public can view it. The other members of the panel joining me today are Judges Lambert and Wallace. How much time does appellant wish to reserve for rebuttal?
5 minutes, Your Honor.
Okay. All right, then we'll go ahead and get started. You may proceed.
Thank you, Your Honor. The plaintiff in this case argued that in every case in which causation is found, regardless of the availability and payment of PIP benefits, and regardless of an aggravation instruction, and regardless of a reasonableness instruction, the jury must award the entire cost of the same-day hospital visit as damages. This is simply stated not the law. If so, then in every single automobile accident case, there would be a minimum verdict, which the judge, the trial court, would be required to award every single time. In this case, the plaintiff made this argument at the time of trial. And the trial judge specifically ruled that, quote, I'm going to make the determination that the verdict of the jury is not inconsistent based on the evidence that was presented. They've made a determination that the medical expenses in the past not paid by PIP is an amount of zero. I have to respect that decision. I can't second guess any alleged confusions. So, Judge, here what's happened is that the plaintiff in his motion for new trial argued that where there was causation, there must be damages regardless of PIP. But the plaintiff never cited any cases that stand for that proposition. So, Judge, where we are and what this court's determination must be is to look at 3 reasons that the trial court's ruling was erroneous. Those reasons are, number 1, that the jury made an appropriate deduction for PIP benefits and awarded those damages that were related to the accident and determined that those damages were related or were covered by PIP. Number 2, there was an aggravation instruction. The jury was entitled to determine what portion of the expenses at the hospital were related to the accident and what portion of those expenses were related to any aggravation of the.
How do they do that?
Your Honor?
How do they, so they get it, they hear that this guy goes to the hospital the day of the accident and they see a hospital bill that's admitted to evidence, and you're saying from that they can say, well, this x-ray is okay, but this one's not okay, that's from a recoverable thing. That's your argument here, that the jury parsed that out?
Your Honor, my argument is specifically that the jury was instructed to do just that. They were instructed on aggravation instruction. This court, in the Schwartz case that we cited, Your Honor, this Fifth District Court of Appeals said that when the plaintiff fails to move for a directed verdict on such an issue, they waive that. They waive that issue. So what's happened here is that
Schwartz is a little different because they found it was not causally related. They found there was no damages caused by the squishy tomato or whatever that thing was.
Yeah, pumpkin. Yeah, you're exactly
Pumpkin,
right.
all right.
But also the finding in that case, though, was specifically that where the plaintiff failed to move for a directed verdict, then he can't later come on an issue such as aggravation or an issue such as reasonableness. Then you can't come back later and say, well, the jury shouldn't have applied the aggravation instruction as it did.
Well, I think that's apples and pumpkins, I guess, with Schwartz. But I mean, because you're saying they should have moved for a directed verdict here, but they got a verdict that says they're entitled to damages caused by this accident. So
true. And let me answer your question more directly. I said, well, number 1, he's waived it because of the directed verdict issue. But number 2, there was ample evidence that there was a pre-existing condition to the plaintiff that would have been symptomatic, that would have required treatment in the absence of any automobile accident, and that at worst was aggravated to some degree.
I mean, I guess I just don't see that Schwartz is applicable here. And just, I don't know if you recall, I'm the one who actually wrote Schwartz. So you're going to have to convince me why you think what I wrote applies here when I don't think what I wrote applies here.
Well, I would say that that is probably impossible then, Your Honor.
Well, you got two other people who probably you can convince them. I'm having a hard time. I think the key to this Schwartz was that there was a finding of no. Schwartz was a scenario where we said, okay, look, when you roll the dice with the jury and the jury has made a finding that there's no damages caused by this, you can't then fault the jury for doing what they were instructed to do to award no damages if they found there was no causation. Here they found causation. So I think that's the pumpkin to apple dichotomy here that makes Schwartz, in my view, inapplicable.
Well, the other part of the analysis, Judge, and I think the key part here, and in fact, I can't argue things that were not argued here, but this court did determine such an issue in a case of mine years ago, Perez versus McClish. It was a per curiam affirmance where the court denied a new trial for just this reason. So, but to get away from that, what we have here is also
Mr. Goebel, if I have a question. So at trial, you only disputed whether the accident was caused or the accident caused the injury or damages, correct? You didn't parse out what overall amount of medical expenses should have been covered. Is that correct?
Well, we also argued that the plaintiff sustained at most a sprained strain, and recall that where we showed that was through the testimony of the experts, where they said, well, at most the plaintiff sustained a sprained strain, which is basically a term for where there is no objective injury and there is no evidence of injury.
And what was the evidence from the jury that resulted from your argument right there? The jury never found that only a portion of the damages were caused by the accident. Is that correct?
I would respectfully disagree, Your Honor. I would say, here's what I believe is the case, and I believe is appropriate. I think in a case such as this, what the jury did was entirely appropriate and probably should be the verdict in cases like this, where it is a sprained strain type situation. Because really what the jury should be doing is exactly what the jury did in this case, finding that there was causation, for example, for a sprained strain, but that PIP covered all of the damages related to that sprained strain. So that's what the jury certainly could have determined at this point. So they could look at
PIP covers 80% of the cost, right? So
that's
what about
true.
the other 20%?
So the jury could certainly find that in this case, remember, the big issue in this case was the plaintiff's low back, the spondylolisthesis. The overwhelming evidence, in fact, I think the only evidence at trial was that the spondylolisthesis pre-existed the accident. There was not one expert that said it did not. Now, there was also additional testimony that said that spondylolisthesis, spondy, as it was called at trial many times, was going to need treatment regardless of the accident. There was testimony from both the plaintiff's experts and the defense experts that they would either not be surprised if it was symptomatic before the accident, or that it in all likelihood would have been symptomatic before the accident. So what the jury certainly could have done, and was certainly supported by the evidence at trial, was that the pre-existing back problem, the spondy, was wholly unrelated to the accident. It needed treatment and evaluation in
your own expert, didn't your own expert testify that that it's likely that the plaintiff suffered a sprain or strain that could be reasonably resolved with 6 to 8 weeks of conservative treatment?
I think what he testified, Your Honor, that at most he had a sprained strain, and then he was very specific, saying that meant that there was no objective evidence of any injury.
Did he say at most, or did he say likely?
I think he said at most, Your Honor. Okay. I think, and that's Dr. Jenkins specifically.
No, I'm talking about Dr. Meinhardt.
Dr. Meinhardt. Well, then we had two different opinions regarding that, at least. And going to Dr. Jenkins, he specifically said, and the jury could certainly look at his testimony, where he said it was at most a sprained strain, and that meant that there was no objective evidence of injury at all. So the jury could certainly find that if there is a sprained strain, what they're talking about there is the neck. Okay, because there was two alleged injuries in this accident. There's the alleged injury to the neck and the alleged injury to the back. So the jury was entitled to look at that and say, well, we don't believe that there was anything that happened to the back, and put all of the evidence in this trial together for that. Because remember, one of the biggest things in this trial, and the exception to the rule on awarding damages specifically after the accident, and Your Honors, we cited to those cases dealing with the exception to the general rule. And the exception to the general rule certainly applies here. And I think in Schwartz even, Your Honor, going back to that case, there was the issue of the exception with respect to one of the key pieces of evidence that we had here, which was biomechanical testimony. We had biomechanical.
In his order, the trial judge said, when a damage award is clearly inadequate and the issue of liability was contested, it gives rise to suspicion that the jury may have compromised its verdict. And he cited Cowan for that proposition.
He quoted from
Right, he quoted from it. So in determining whether there might be a suspicion of compromised verdict, can the trial judge consider that one of your experts indicated that could well have been a strain or sprain that would require conservative treatment? Even if you had one expert go one way and one go the other, when the trial court's making a consideration whether this may have been a compromised verdict, and the trial court consider that one of your experts took the position that he did.
Well, Judge, certainly the law is set forth in the Van versus Schmidt case. The Supreme Court set forth the standards for the evaluation of an order granting a new trial. First of all, if the trial court was going to do what Your Honor suggests, it was obligated to put those findings of fact in an order. It did not. What the trial court specifically did here was cite to the Cowan case as the legal standard upon which it was bound, by which it was bound. That puts this case squarely within the de novo standard of review and the legal standard of review. So that gets us, I think I got away from your question, Your Honor. Can they look at the conflicting testimony? I think
among your own experts.
Yes, I think they can, but I think they have to look at it in light of all of the evidence at trial and somehow determine that the, as the standard is, they must find that the trial court's order explained and demonstrated what led the trial judge to conclude that the jury verdict was wrong. And the basic standard, remember this, before we even get to what Your Honor is suggesting, the basic standard is that the trial court is not supposed to act as a seventh juror. When the jury has this evidence in front of it for its consideration, what the trial judge is supposed to do is only make such a ruling if it is against the manifest weight of the evidence. So what manifest weight of the evidence would be here, where there was all of the evidence that was in front of the jury? And I think I detailed that in our brief, but just to cover that very quickly, we had the biomechanical evidence, we had the evidence that the spondylolisthesis would have been symptomatic in the absence of the accident. We had the evidence that it would require treatment in the absence of the accident. The plaintiff's credibility was severely impeached in this case. There was evidence that there was no objective injury at all regarding to the plaintiff's low back. The plaintiff's experts were severely impeached on that issue. There were significant gaps in the plaintiff's treatment. I think there was 15 months at one point with no treatment before the surgery ever happened. There was surveillance that starkly contrasted with the plaintiff's statements regarding his physical abilities. And remember this, Judge, there were the plaintiff's statements to his own treating physicians regarding the severity of this accident, where he claimed that he was hit going 50 or 55 miles an hour while he was stopped at a light. He's knocked 30 feet into the intersection, where there is almost, if there is any visible damage, it is almost invisible, or it is invisible in the photographs that were submitted to the jury and put into evidence. And then when you tack that on, Your Honors, to what the plaintiff said at the scene, which severely hurt his credibility when he told his children to never admit they weren't hurt in an accident. So when he put all that together, Judge, I think it is not out of bounds for me to say that it is impossible in this case for anyone looking at the evidence here to objectively determine that the jury's verdict was against the manifest weight of the evidence. So that gets us back to the legal conclusion that the trial court made and gets us back to the fact that this should be a de novo or is a de novo standard of review. And then the ultimate question is, can the jury in such a case apply the PIP deduction and determine that the portion of the medical bills actually caused by the accident were covered by PIP? And those are the instructions in this case. And in fact, what the plaintiff argued in this case. That's what the plaintiff argued in this case in closing, was if you find those bills are related, then you should award them. Talking about those bills specifically at the hospital. So what we're looking at here ultimately, I'm sorry, I'm out of time and I've reserved 5 minutes.
All right. All right, for the appellee.
May I proceed?
Yes, you may.
Thank you, Your Honors. I am Mark Equinez. I represent Mr. Bergman for this matter, and I appreciate your time today. Our primary thrust in this case is that the jury did return an inadequate verdict. Arguably, it's inconsistent. The legal law in Florida is it's not an inconsistent verdict, which is why the learned Judge Karsten at trial said it's not an inconsistent verdict. That is 100% in line with the case law from the state of Florida. However, it is an inadequate verdict, and it is potentially and very obviously a compromise verdict when you look at all the hallmarks of what we say when we review the case law of what a compromise verdict is. So most importantly, when we look at why is it an inadequate verdict, we have the jury returning a verdict that says, yes, Mr. Sykes, which was the tortfeasor, the defendant in this case, State Farm was an uninsured motorist carrier. So the defendant, or the tortfeasor in this case, was found to have created loss, injury, or damage to Mr. Bergman, but they found absolutely no damages at all. They didn't award medical bills, they didn't award anything, pain and suffering, none of it was awarded.
Let me ask you this.
Yes, Judge.
Since this is the second oral argument, we seem to be talking about cases or opinions I've written. If the jury had answered question number 1, no, instead of yes, do you then agree that Schwartz would apply and your case would be over?
Absolutely. We had the same verdict form you had in Schwartz. And having read Schwartz, I have to reconsider how I do that in future trials. But the verdict form, which we approved, specifically said, if you say no, then you have to stop, which is, I understand your opinion in Schwartz. That's why the case couldn't go forward. There's some other distinguishing factors that we could talk about in Schwartz that you found as well. But most importantly was the fact that they found no, and they were told to stop. How can they go on when the verdict form itself says stop? So and that was my reading of your analysis in Schwartz. And if I've gotten it wrong, it wouldn't be the first time. Please tell me.
Oh, that's right. Let me ask this other question. So the judges entered an order granting a new trial, as I understand it, on liability and damages. And what do you think about your opposing counsel's reply brief that says, well, under Hummel, it should just be limited to tangible damages? What do you think about that?
When you have a compromise verdict, you need to look at a retrial on all elements, because unfortunately, when you have a compromise verdict, as you've seen in the cases that have been presented to you, and I've actually, I will take the liberty of mentioning case. Unfortunately, I did not previously cite. Counsel did the same, and it's not to backslide. I just didn't see this case before, but it's got some great language in it. It's FLNC versus Ramos at 220 Southern 3rd, 1220, if he wants to look it up. But the hallmarks of it, and this was a nursing home case. It was totally different than what we got going on here. But the hallmarks of a compromise verdict and a tort claim are clearly inadequate damage. We got no damage awarded here, so it's inadequate, coupled with a finding of liability in a case where liability was hotly contested. Now, in their reply brief, State Farm wanted to argue that liability was not hotly contested. And the question is, what is liability? We use that term in such a way that it becomes confusing. Are we just talking about who caused the crash? Right. By the time we got to trial, they had finally admitted that the rear end by the tortfeasor was the cause of the crash. We didn't litigate that in front of the jury. We litigated extensively the causation of injuries. In other words, that liability, whether State Farm was liable for paying for the injuries of Mr. Bergman to his back and to his neck. And so we had experts and they had experts. We had a biomechanical expert. They had a biomechanical expert. We had a radiologist. They had a radiologist. They had an orthopedic surgeon, Dr. Meinhardt, who in fact did testify similar to what I was hearing earlier. I pulled up the language just to be clear. It's found on the transcript at page 2310. The question was, what type of care and treatment would have been reasonable and necessary for the injury that you described happened, in your opinion, as a result of this accident? And Dr. Meinhardt's answer at line 23 was, as I've noted, 6 to 8 weeks of conservative treatment, including physical therapy and anti-inflammatory medication and intermittent use of muscle relaxant potentially. So their own expert, this is actually the doctor that they got to touch Mr. Bergman. They brought in a neurosurgeon, Dr. Jenkins, over my objection to really just re-review the records, repeat the same testimony, and come up with a couple opinions of his own. It was allowed over my objection, but Dr. Jenkins said some other things, but they absolutely had conflicting testimony, even within their own experts. So we have, I'm sorry, did I interrupt?
No, let me see if I can cull down a little bit what Mr. Goebel's saying. The jury's instructed to basically consider not award damages that have been paid by PIP already. If I'm understanding his argument is, or if I'm extracting on his argument is, let's say based on his expert's testimony, 6 to 8 weeks of conservative treatment is appropriate for the injuries sustained by your client from this rear end accident. PIP paid their 10 grand. If 6 to 8 weeks of treatment, including the initial hospitalization, is under 10 grand, why isn't then the verdict of, well, the jury's got this, said, well, you got 10 in PIP, the first 8 weeks of medical bills is under 10, so 9 minus 10 is 0 in their mind, or 10 minus 10 is 0, therefore I award 0, and we find no permanency, so 0 it off and off we go. Why is that not a fair or an appropriate reading of what the jury's verdict said, such that the judge abuses discretion, if we want to use the abuse of discretion standard, in granting a new trial under Cowan? I think that's his best argument, I believe. What he's trying to tell us best. Like,
And I appreciate.
If I'm wrong, he could tell me on rebuttal if I've misstated it. But go ahead.
Okay.
That's my question.
I appreciate the question very much, because I want to make sure that I'm able to convey to you that the PIP argument is a shell game. And I don't mean that in a disrespectful way, but it's something the jury could have bought into from the closing argument from the defense when they were told over objection that they could award 0. And in particular, in response to the example you gave, the 6 to 8 weeks would have been more than the 10,000. But putting that aside, the real reason that it's a shell game is this. Let's just assume, for the sake of argument, that the hospital bill, it was more, but it had to be more, But let's just say it was $1,000. Under the PIP statute, there's an immediate, hospital bills are a little bit different. You immediately take 75% of the hospital bill. The other 25%, basically, the hospital has to write off. So now you got a $750 bill. PIP pays 80% of that, which, take my word for it, the calculator says is $600. You still have $150 that the jury was instructed to award. Now, if they say that well, but only part of his treatment, only half of that $1,000 was a result of the crash, the other half was pre-existing condition. They somehow speculated, because while they were given an aggravation instruction, and that is the standard instruction on aggravation, they were given no information by which they could reasonably conclude or separate the injury. The plaintiff's doctors said they couldn't do it. The defendant's doctors didn't even try. But let's again assume, for the sake of argument, that they did. 50% of it is aggravation, 50% of it's new. They could have come up with the number does not matter, because let's say there's a $500 bill now that's responsible from the hospital. The other $500 was Mr. Bergman's from pre-existing. PIP pays, 80% of 75% of that $500. In other words, $300. But Mr. Bergman owes the other $200. I'm doing bad math, but PIP only pays a portion of it because I got to take 75% of the 500. Mr. Bergman would owe $75 out of that $500, and they should have awarded that $75 as compensation.
I get where let me change my hypothetical a little bit. Let's say that instead of telling the jury to do that, the parties through counsel had said, you know what, let's just have the jury enter whatever number they think is appropriate. We'll all agree that the judge can do the set off post verdict. And the jury then comes back and said, we award medical expenses to Mr. Plaintiff of 10 grand. And it doesn't differentiate, says, you know, this for this bill, because nobody has verdicts like that, verdict forms. And then you come to the judge post verdict and State Farm, and let's put State Farm into the equation of my hypothetical. State Farm says, okay, well, the jury awarded 10 for medical bills and nothing else for past medicals. There's no dispute that PIP's been paid 10 grand. 10 minus 10 is 0. We need a judge. You ought to enter a judgment for State Farm. It's a net 0. Would that have occurred under my scenario?
It absolutely could. And I can tell you that years ago, I had a trial with the Honorable Judge Thorpe, and the jury awarded part of the medical bills, but not all of them. And I was in the uncomfortable position of presenting an argument that academically I didn't like, but legally I had to make, which was to say the jury did not itemize what they paid, and they could have paid the bills that were, or awarded the bills that were paid by PIP, or awarded some other bill. And she had to say they don't get a set off, because in that case, we did agree, contrary to statute, by the way, to do the set off post trial. Since then, I've never done a set off post trial. I do exactly what it says in the statute. I tell them to award the PIP, the medical is not paid.
Well, I think Justice Quintero actually wrote an opinion about 2005 that basically said, you know, this is what you all need to do, even though you might have done it differently in the past, i.e. us old insurance defense lawyers from 25 years ago.
Right. And that came out after my trial with Judge Thorpe.
Mm-hmm.
So in answer to your question, yes, it's an issue. It's a problem that can occur if we do the post-trial set-off. But if it's obvious, I think there's a case out there, and it may be the one you're referring to, that says if it's obvious that what they awarded, this again came out later, was, you know, the amount paid by PIP, then regardless of the lack of delineation and specific itemized bills being awarded, then you can actually do the set-off, and that works. But it just creates issues. So historically, for the past 10 plus years, more than that, I have done what the statute directs.
Mr. Goebel's saying that the issue before us, our review here is de novo as opposed to abuse of discretion. What's your response to Mr. Goebel's argument there?
Well, you did a de novo review in Schwartz, and that was because the issue was on the face of the verdict form. But as soon as Mr. Goebel and State Farm want to talk about treatments and testimonies, and he went through a list. I wrote them down: 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 or 11 items that are all factual disputes, and basically said the judge shouldn't have looked at that when he is the trial judge and he's in the best position to do it. More importantly, it's not just an abuse of discretion review. The case law says that there are 2 abuse of discretion standards. This is news to me after doing this appeal, but the standard that you must find to overturn the granting of a new trial is a higher abuse of discretion than the standard that you would have to meet if you were overturning an order denying a motion for new trial. So this is the highest abuse of discretion standard you can see. In my estimation, it's basically the highest standard I think we're going to see in civil courts. You get into criminal courts, perhaps we have even higher standards, but this is going to take a lot of this was just plain wrong to overturn it. We didn't have one of the problems in the whole, you know, the jury decided.
And Mr. Cornelius, Mr. Goebel highlighted some of the evidence that he believed was overwhelming as far as why the jury awarded 0 in damages. Your case, if I'm reading your case, the facts of your case properly, your best evidence is the evidence of a sprain or strain and evidence that it could have been remedied within 6 to 8 weeks as a reason why, at a minimum, the ER expenses were reasonable to diagnose that problem. So moving forward, your client could have moved towards recovery. Is that correct? Or is there some other evidence out there that you believe supported the judge granting the new trial applying the abuse of discretion standard?
I do believe that what you have cited to does support the affirmance of the new trial. But in addition to that, the case law says that even if the diagnostic testing done after the crash shows nothing, you go and there's nothing absolutely wrong, you still are required to award, under these facts, where the jury found some damage, to award some, I'm sorry if you guys hear that too, I apologize, I don't know how to get rid of it. The hospital bills and the ER bills that directly follow the crash. And that's the facts we've got here. Mr. Bergman gets in a crash, he goes to the hospital within hours, he gets diagnostic testing with regard to symptoms that are from the crash that weren't there prior to the crash. And this is where the facts become hotly disputed. They want to say, well, he couldn't have had those symptoms. Of course, he says he had them. His wife and family talk about, how he acted, which was consistent with having such symptoms. The facts of the crash are that we actually have an audio tape that talked about the tortfeasor saying he would have gone through the window if he didn't have his seatbelt on. So it's, we got a lot of contradictory facts here. It's hotly contested. Now, this is a different argument, and that's sort of, I don't want to mix my apples and oranges, because in answer to your first question, that was really the inadequate verdict argument. Now, when we start talking about the hotly contested nature of the case, along with the inadequate verdict, that is, as you saw in what the cases that are cited in my brief are provided as well. But that is the hallmark of a compromise verdict. You've got a jury that's back there. They don't agree on what they should do. They say, yes, we're going to say he's injured, but we're not awarding anything. And so somehow that makes them happy. It just calls into question the entire verdict, which in answer to one of the questions I had earlier is why we have to redo the entire thing. And that's what the cases say very clearly. When you have a compromise verdict, you can't just do part of it over. You've got to send it back and hopefully get a jury that understands the law better. Because while we do give them the aggravation instruction, because that's the standard instruction, they have to have some basis. They also get the instruction that they can't speculate. They have to have some basis upon which to apply that instruction. And without facts in the record, facts that they would have had to rely upon to do what State Farm is suggesting, they can't.
Let me ask you about the aggravation instruction. I know Mr. Goebel talks about that today and in his briefs. I mean, the aggravation instruction, I guess that's to the low back, the spondy claim, as you all refer to it below. I mean, that basically tells the jury that if there's an aggravation of a pre-existing injury and you can make a determination, you should only award damages resulting from the aggravation. And if you can't make the determination, then you award damages for the entire condition. So maybe I'm misreading that instruction, but that would seem to me to say that even though your client had Mr. Bergman had this pre-existing condition, if it was simply aggravated and they were able to differentiate, then they should award some damages for the aggravation, the treatment of the aggravation. Isn't that how that reads, that instruction? Or no, am I missing?
It's almost exactly how that instruction reads.
Okay.
However, they can't separate out the aggravation from the pre-existing condition without some testimony, without some evidence that allows them to do so. Otherwise, they're simply speculating about what was pre-existing and what was there caused by the crash. In speculation, I've also provided in my brief that a speculating jury is not permissible, and a verdict based on speculation must be reversed. So it was suggested to this court that there was ample evidence that Mr. Bergman had to be symptomatic before the crash. In fact, there was not ample evidence. Dr. Mahan said he would not be surprised if Mr. Bergman was asymptomatic before the crash. The only people that said that they would have thought he may have had symptoms where Dr. Harper, I believe, said he may have had symptoms, and Dr. Jenkins said he would not be surprised if he had symptoms. Not a single doctor said he had to have had symptoms before the crash. There was no such ample evidence. There was some evidence that he may have had symptoms before the crash. But I can tell you, as stated in my brief, State Farm put out a wide web of subpoenas to find any and all evidence in prior treatment to Mr. Bergman's low back, and they came back completely empty-handed. Not a single doctor treated his low back prior to this crash. Your Honors, I'm going to be done here with my time, so I appreciate your time. This is an inadequate verdict. It is an abuse of discretion standard, and the PIP suggestion simply does not hold water because they had to pay an award in damages, at least a small portion of what PIP, the portion that PIP did not pay. And finally, most importantly, this is a compromise verdict. This has got the hallmark of a compromise verdict. Liability was hotly contested. It's an inadequate award when you get zero for damages that they said were there when they answered yes to the first question. And therefore, the order below should be affirmed. Thank you very much.
All right, thank you. Any rebuttal, Mr. Goebel?
Yes, Your Honors, I have 3 points I'd like to make. Number one, the plaintiff says this is a shell game by the defendant. But remember this, the plaintiff put in the med pay, he put the entire hospital bills in, showing that med pay paid the entirety of the remainder of the bill and the hospital wrote off any remaining balance. So he put in the inadmissible evidence, and now he's complaining that the jury relied upon that and awarded no damages.
Well, what did the trial judge instruct on that issue?
Yes, the trial judge gave the standard collateral source instruction. That's correct.
Okay.
But
Wasn't that, Mr. Goebel, that was specific to MedPay. So it may not have affected the jury's working with the PIP benefits, but it did specifically address MedPay, correct?
the collateral instruction, collateral source instruction, I'm sorry, Judge, I'd have to look at it again and see.
It talks MedPay or other sources.
Does it? Okay. All right. So, but in any event, the whole point that I'm making is the plaintiff put that evidence before the jury. So the jury looked at that evidence and ultimately determined that the plaintiff sustained no damages or did not incur any damages that were not covered by PIP because of what was in the hospital bill. Then the plaintiff invited that error. So that's the first point I'd make. Now, what did the jury ultimately find here? The jury found that any damages incurred by the plaintiff were covered by PIP. That's the only logical explanation for what the jury determined. And just like Your Honor said, if this is a post-trial set-off and the jury awarded $10,000, then the post-trial set-off would end up with a zero verdict, which is exactly what we have here. Now, third point, and I said—
But the context of my hypothetical would have been different, because at that point you're asking the judge to say, okay, we know they've awarded 10 grand for medical bills, but we don't know which medical bills, and all we have is a 10 grand PIP payment, and now you toss it in my lap, and so the only logical thing that I can do is, A minus B, where here the instruction says, look, PIP is taken into consideration, but the hospital bill, as your opponent talked about, there is some percentage of the hospital bill that's not paid by PIP, and that should have been awarded at a minimum. And that's why it's different here based on how the case was presented and the instructions given.
And, our side of that equation is, Judge, the jury can look at that and then determine what portion of that bill was related to the accident. They're entitled to do that. And we had plenty of evidence, overwhelming evidence, that the spondylolisthesis, the plaintiff's low back, would—
Doesn't the jury have to have some basis in the record to do that? I mean, in other words, a doctor would have to come in and say, it is completely unreasonable for this man to have gone to the emergency room that day of the accident to get checked out, and therefore the bill is unreasonable. I mean, the jury just can't just say, well, the hospital bill is $4,000, but we think a hospital bill should only be $42.12. Therefore, that's all we're going to award. I mean, do you have something that says they have the ability to do that? Absent some—
That's not the— and respectfully, Your Honor, that's not the point I'm making. That's not where I'm going with this.
Okay, go ahead.
Okay. I mean, there is that issue where they're instructed to award the reasonable value of the bill, the reasonable value of the medical bills. That was in their lap. That's what they're instructed to do. You can't fault the jury for doing what they're instructed to do. So they certainly could have made that decision. But here's the point. In this case, and Your Honor is saying, well, how would they determine that the back injury had no bearing on this accident? I've got 40 seconds. I would say there is evidence that it was pre-existing. Dr. Jenkins specifically said that he would be very surprised if a person with these findings did not have symptoms. And I'm looking at page 1885 in the transcript. And then you have the issue of the biomechanical testimony that showed that his back did not move. Now, I'm going to hit two more things in 30 seconds. The trial judge did not set forth any explicit articulated matter of record in its order awarding a new trial. Conclusory statements, and this is in this court's cases, Hashmi versus Staples, that's Judge Evander's case. Conclusory statements without any cited factual support must be reversed. A trial court abuses its discretion when its reasons for granting a new trial are not supported by the evidence, not supported by the record. The trial court cannot act as a seventh juror. So, Your Honor, the trial court should only intervene when the manifest weight of the evidence dictates such action, and he did not set forth any findings of fact that showed that the manifest weight of the evidence dictated such action.
Okay, well, thank you, and thank you both, and we'll be in recess.